fair enough. But why? Why did this happen? I want to get back to that. Why, as the DOJ, do you apply Bruen sometimes and not other times? Because that seems to be what she is wanting to do here, is picking and choosing when your Bruen analysis is appropriate and acceptable. And is it because the Hawaii case is low stakes for her?
We're the Armed Attorneys. Today we're talking about Pamela Bondi, kind of talking out of both sides of her mouth, talking about the National Firearms Act, the one big beautiful bill, tax stamp 0. How is that being challenged? Gun owners of America stepping up. And then the vampire rule out of the Ninth Circuit, which is being taken up by the Supreme Court, and kind of her surprising position there, and so much more. But before we begin, show your support for the Second Amendment by hitting that like button. And if you're not already, join us over at armedattorneys.com. Join the Armed Attorneys Insider newsletter. It's the only place that we can't get censored, YouTube. But a lot of folks, we do get that reply a lot. Hey, I signed up, I didn't get anything. It's because we don't send out stuff very frequently. We really send it out maybe once a month-ish. So just be patient.
Yeah, we wait for a big update or a big case.
We're not going to spam you. Yeah. So that's what that is. But today we're talking about the National Firearms Act, the $0 tax on short-barrel rifles, shotguns, suppressors, AOWs, how that's going to play out. Is it going to cause the NFA to crumble? Well, the GOA is kind of taking the lead on this one.
Yes. If you are not a GOA member, and I don't get paid anything when you become a GOA member, they're not paying us for this channel, but we do, help them with their legislative efforts. We like them. We think they're the best out there. Join GOA. GOA does really good stuff for you, not just on the case law end of it, but really all over your gun rights. GOA is all over your gun rights.
Yeah. So, and we'll back up just a little bit. National Firearms Act, 1934. We have it being kind of upheld. I have to reference this. 1937 Sonzinsky case saying, hey, look, NFA is a legitimate exercise of the Congress's taxing authority. Well, all right, big beautiful bill signed into law effective July the 4th, 2025. Through some finagling, the tax on those items, short barrel rifles, shotguns, suppressors, NFA items, or AOW, reduced to $0. Okay, so for justifying the NFA as a legitimate exercise of the Congress's taxing authority, and the tax goes to 0, what happens?
Right, which I think is a winning argument. I think it's a winning argument. I think if there is a $0 tax, this is no longer justified on the basis of the tax power, and it just becomes like an illegal gun registry.
Yeah.
That's what we got. I believe that to be the case. However, who doesn't? Who doesn't think that's the case, Richard?
Pamela Bondi.
Also, yes, we are. What a frenetic set of policies wrapped up in a little blonde human this has turned out to be. Yes. So
it doesn't matter what we're talking about. A certain person's client list, talking about the NFA. None of these. It doesn't seem to make sense.
No, Pamela Bondi rarely agrees with Pamela Bondi.
Yeah.
on anything that's going on.
That's very funny.
Here we go. Step one of what's happening here is this NFA challenge, which we covered on the show last week, which I was very annoyed about. All of the Republican lawmakers who wrote the letter to Bondi and said, listen, Bondi, we really, our intent, I know we didn't really do it, but our intent was to dismantle the NFA. So please do that for us, which at the time we got very annoyed about and said it was performative nonsense, because it is, because that's not what they did. But again, that's the point, right? The point is, but do our job for us, Pam Bondi. And we talked about all the reasons why that wouldn't work. But had she done it, well, that would have been cool.
Yeah.
It would have been cool.
Yeah.
But what did she do instead?
So, and if you want to follow this case along, this is in the United States District Court for the Northern District of Texas, case number 625CB56H. Now, this is the one big beautiful lawsuit by gun owners of America challenging the constitutionality of these provisions of the National Firearms Act. We just got a response from the Department of Justice, a la Pam Bondi, basically changing the government's position that they've had for nearly a century. And what she is, they've retreated from the, hey, and this is another case I think that's important, worth referencing. This is the United States v. Constantine. This is in 1935. And it says that a provision that does not generate any revenue can't be a tax, can't be justified as a tax. And so, all right, put all these things together, clearly this is a winning argument. Congress is not exercising its taxing authority, even though that's enumerated in the Constitution. So again, government changed its position. Now we're focusing on the Commerce Clause and the Necessary and Proper Clause.
Right. And I guess there is an argument that it is her job to defend the laws when challenged. But I don't think that you get to just knee jerk back and change positions that are long held in order to do so. I don't know. Maybe I'm expecting too much. When's the last time they just folded on something? I mean, does she feel like she has to defend this?
I mean, they did fold on FRTs. Again, I don't like these settlements because they're kind of worth the paper they're written on. Change administrations, change just one circumstance, right? Settlement not necessarily going to be binding anymore if the government really wants its way. But I will say, I mean, the things that they point out in their response in the Northern District of Texas, changing our position from, all right, not a tax, worried about commerce. Well, guess what? If our founders, and do you think our founders would have envisioned that 95% of our government exists based on the Commerce Clause? They were,
No.
I mean, they were concerned about the Necessary and Proper Clause.
No, they are rolling in their graves at the size of our government and at how much control it exerts over us. Rolling.
Right. And so the Necessary and Proper Clause, just for a little bit of context, this is basically saying, hey, if it's an enumerated power under the Constitution, you can basically carry out the things to effectuate it. Clearly, we're not going to spell everything out for you. Okay. All right, I see that. Commerce Clause, way overpowered, needs to get reined in. Maybe this is the case to do it. I doubt it.
No.
But we have those two arguments coming from the government. And really what she seems to be citing, and I'm hoping we get a narrow opinion here. I mean, she's supporting kind of the back end of all this for manufacturers of these items, for people who sell these items, because, that $0 tax didn't really affect all of their licensing. They have to pay money to keep their licenses and things like that. Those weren't reduced to zero. And so maybe we get a narrowly tailored decision where, all right, we get rid of the Form 4 stuff. People don't need to register their firearms anymore. The tax is zero. Maybe we keep the licensing scheme in place for these manufacturers and dealers. I don't know.
Maybe, optimistically, maybe this is a half-hearted response from the DOJ so that we can get such a decision.
Yeah, but people are mad.
I don't think that's the case. But yes, well, and all right, okay. I think that we should move on to the next case because I am annoyed at the mealy-mouthed nature of what has just happened in Hawaii.
All right, so yeah, now get ready for your Pam Blondie whiplash because we have a completely different, different day, new DOJ, new Pam Bondi, because, and this is what we're talking about with the second case in the Hawaii vampire rule case. If you haven't been following this, and that brings us to a new Supreme Court case, Wolford v. Lopez. This is 23-16164, if you wanted to follow along. And in this case, we had Hawaii, in the wake of getting forced to change to a shall issue state because of New York State Rifle and Pistol Association. Well, guess what? They decided, hey, let's make gun ownership as frustrating as humanly possible here in the Aloha State.
Call that the Hochul Plan.
Yeah, golly. And so they passed this rule, but basically it was presumptively unlawful to carry generally in public unless you receive basically express permission from these private property owners. They banned firearms in all kinds of places. And what happened next?
So what we have is at the district court level, the Second Amendment won. The district court said, actually, this is an unlawful infringement. You cannot ban guns on other people's property as your default until and unless that private property owner says, sure, I'm going to explicitly allow it. We don't restrict the Second Amendment that way. We don't control private property owners that way, frankly. But of course, that's the district court. It's appealed to who covers Hawaii? Why the Ninth Circus? We have one subscriber who greets us every time. Who lives within the Ninth Circuit, and he says aloha from the Ninth Circus.
Yep,
every
spirit
time.
of aloha sometimes.
Yes, that's right. So yes, the Ninth Circuit, which with rare exception, always does the wrong thing every time when it comes to guns.
Statistically, it's wild. You'd think they would get it right by accident every now and then.
Well, every now and then they do get it right.
Sure.
And then they rehear it en banc, and then they get it wrong.
Yeah.
So we have the Ninth Circuit, of course, saying, no. You can have all your vampires that you want. It's not a big deal.
I love that name, by the way.
Me too, especially because Halloween has just passed as this video is airing, right? About a month out, and that's my kid's favorite. Like when I was like, what noise does a vampire make? Because they're toddlers and they go, bleh.
Yeah.
But yes, I will.
that was the longest. What do you call that set? Is that a vocal fry? That was the longest vocal fry. You set a new record on that one.
But yes, this vampire rule is upheld, and it should not be a shock. It includes not just this vampire rule, but the Ninth Circuit has in the past upheld restrictions on public beaches, parks, playgrounds, bars, restaurants serving alcohol. I mean, there is no...
Yeah, they found some provisions unconstitutional, but it really didn't make a splash.
Correct. So now we have an appeal to the Supreme Court. The Supreme Court has agreed to hear it. I thought the Supreme Court will do the right thing on this one because it's easy. They're not going to make any big, painful decisions for a very long time. But I think they'll do the right thing on this one. But all of a sudden, Pam Bondi pokes her head up with an amicus brief, which is a very interesting one.
Yeah, she is pointing out, and I'm not aware of another Second Amendment case where the Department of Justice takes the side of gun owners. This happens to be an amicus. This is a friend of the court brief saying, you know what, the United States government takes the position that this Hawaii law is unconstitutional. No text, history, and tradition there. There's no kind of precedent for this stuff. They really, and maybe this is kind of like a self-preservation argument. New York State Rifle and Pistol Association v. Bruen is not being properly applied. Give the court an opportunity to, and the Supreme Court needs to do this more frequently, is just summarily overturn things and send them back. They don't need to write out big written stuff. And maybe we get that in this case. But we don't see a lot of district courts or intermediate courts of appeal anytime there's a Second Amendment issue, just summarily shutting it down because the improper standard was applied, which needs to happen. Maybe it gives the United States government a break because it lets the Supreme Court strengthen, clarify some of these issues. I don't know. I don't practice in the United States Supreme Court, but I see this as an opportunity to maybe save us some taxpayer money if we get, yes, we meant what we said in New York State Rifle and Pistol Association v. Bruen, apply this standard. I think that would probably save us all some time.
Yeah, fair enough. But why? Why did this happen? I want to get back to that. Why, as the DOJ, do you apply Bruen sometimes and not other times? Because that seems to be what she is wanting to do here, is picking and choosing when your Bruen analysis is appropriate and acceptable. And is it because the Hawaii case is low stakes for her, and it's viewed as like a gun win to splash up on the headlines?
I think it's just a coincidence in politics, and there's never any deep thought or anything to this.
Yep, sure enough. End of story.
No way. Your guess is as good as mine. I'm interested to see what you folks think about that because, what is the motive here?
What is the motive? That's what I'm bothered by.
Yeah.
What is the motive and why?
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, please question and comment for us below. Don't forget to go to armedattorneys.com, sign up for the newsletter if you want some firearm legal updates. And until next time, we're the Armed Attorneys.